Right, welcome once again to continuation of our discussion of medical negligence or clinical negligence. So the last time that we met, we discussed the establishing duty of care and breach of duty of care. So tonight we propose to continue with the discussion of causation, but I remember asking you to go and read the Bolam case if you have not read that. So can anybody volunteer to tell us what he read about the Bolam's case? Just raise up your hand and then I'll call you. So nobody read it. Okay, good. So since nobody read it, we continue. Yeah, so just to recap, so the last time we met, we made the point to establish the breach of duty of care in medical negligence cases. You first of all need to determine whether, I mean, the requisite standard of care. In other words, what is the yardstick which you are using to measure the conduct of the defendants? And we made the point that, well, ordinarily speaking, it is the reasonable man's standard or position. However, in the era of medical negligence, going back to the old case of Bolam, decided in 1957, we noted how the courts have tended for so many years to say that if there's a complaint of medical negligence against a doctor or healthcare professional, the courts will have to find out whether what the healthcare professional did is what any other doctor will have done. I mean, reasonable body of doctors, reasonable medical opinion will have endorsed as being the proper practice to have engaging at the material time that the alleged negligence took place. If what the defendant doctor has done is what other doctors placed in his shoes will have done, then Bolam said that the court cannot come to conclusion that the defendant doctor is actually liable for a breach of duty of care, because what he did, there's a responsible body of medical opinion, which also insists that they will have done it the same way that he handled it. And we noted how the Bolam approach created impression that the courts were unnecessarily differential. The courts were showing too much respect, if you like, as it were, towards the healthcare profession, in the sense that we know from other professional negligence in law of thought that the court will not allow any particular profession, for example, to have the final say as whether the conduct or mission of a member of that profession, for example, can be considered as having amounted to a breach of duty of care, and for that matter, negligence. But in the case of healthcare professional, Bolam practically seemed to suggest that it's like the court, as it were, is abdicating its responsibility, as commentators will say, to the healthcare professionals to actually make a determination as whether a breach of duty of care has occurred or not. Now, this, as we noted, influenced the court in handling a lot of clinical negligence cases. But later on, we saw how the case of Bulaito came to tell us that, well, it is not just a question of accepting anything which other doctors, which the defendant will line up to testify in his favor, will say that, well, they too have done what the particular defendant did, and that the court should accept it. No. Bulaito suggested that, well, the court will need to also scrutinize the basis on which the particular body of medical opinion is based, or the basis upon which those healthcare professionals are saying you have done what this particular healthcare professional did. And if that cannot actually withstand strict logical analysis, then Bulaito suggested that the court would need to probably just ignore that particular medical opinion and do its own, if you like, analysis, as it were. So just bringing our medical negligence to very much close, we would like to look at causation. And in fact, we actually started that the last time that we met, that just as we know that in medical negligence, like other negligence cases, we need to establish this existence of the duty of care. You need to also prove that there has been a breach of the duty of care. Now, that is not enough. We need to establish a nexus, a link, causation between the injury which the person is complaining about and the particular breach of duty of care, as it were. Yeah, so that is important. So the causation is the term whereby the treating clinician or the healthcare professional will be held responsible if his negligent acts or omission resulted in injury to the plaintiff. So where you have therefore established that, yes, and of course we noted that establishing the existence of duty of care is not difficult as far as doctor-patient relationship is concerned most of the time. But where you've also succeeded in proving that there has been a breach of the duty of care, you've still not finished. You need to be able to show that the injury that you are complaining of was as a result of the breach of duty of care, which you have established. And we know that the Bradford test is just applicable, as we know from other thoughts of negligence. For that matter, you have to ask yourself, but for the defendant's negligence, will the plaintiff or claimant have suffered those injuries? Now, as far as clinical negligence is concerned, as we noted the other time, we have practical challenges because the patient, as a plaintiff or claimant, would need to be able to distinguish between two things: the effects of the alleged negligence, and two, the patient's pre-existing condition. So that is a rare challenge, isn't it? Yes, the patient, you've got your own pre-existing condition, and so how you're able to insulate your pre-existing condition from, if you like, the effects of the alleged negligence, so that we see the effect of the alleged negligence and can hold the defendant responsible. So the Bradford test, as we know from law of tort, which we've done already. The well-known case of Barnett against Chelsea, Kensington, where the court propounded the Bradford test. And what it simply means is that the plaintiff is saying that the injury that I have, or what I'm complaining about, I wouldn't have had that but for the negligence, but for the breach of duty of care of the defendant. So that is what the plaintiff is saying. And we know from the Barnett against the Chelsea Kensington case, as we talk about the other day, that yes, because of the poison which the defendant in that case, the plaintiff in that case, were suffering from, you could actually establish that when those at the facility, the casualty department, for example, fail to get the doctor to attend to the patient, yes, that was a clear breach of duty of care. But can we say that the ensuing complication and the death, which we witnessed, could that be blamed on the breach of duty of care? That is, the hospital not getting the doctor to attend to the patient when they were brought to the casualty department? No, because the evidence indicated that even if the patient had been treated promptly, the condition of the patient, because it was arsenic poisoning, it was so serious that no treatment could have saved the patient's life. So that even if the doctor had actually, attended to the patient, because of the condition of the patient, how serious it was still not going to make any difference. And for that matter, causation could not properly have been established. Yeah, so that is one thing that you have to keep in mind, that yes, it may well happen that a plaintiff or claimant is able to prove the duty and breach thereof, but he will fail in establishing causation. And we talked about that the last time. We are just recapitulating what we have discussed already. And we also cited the case of Holt and Edge as another illustration of the Bradford test, which have been developed in the Barnett case. And as you remember, we said that the plaintiff in Holt and Edge during a shower fell and telephoned the doctor. And she did not see her own doctor until the following day. And 2 days later, she went to a hospital, and it was diagnosed that she had a subarachnoid hemorrhage. And as a result, she suffered a massive stroke, and she sued the facility doctor in negligence. And yes, during the trial, the doctor admitted negligence because there was a clear breach of duty of care, as the doctor had not made it possible for the plaintiff as a patient to see her earlier or sooner, as was really needed. But just like Barnett, in Holt and Edge too, the plaintiff failed to establish causation. And because it was demonstrated that even if the doctor had seen her at an earlier stage, that when she fell in the shower, because the patient had not presented any history of symptoms which will lead the doctor to send her to maybe a consultant or to a secondary referral hospital, the stroke will have still occurred anyway, because the history of the patient having symptoms which will have predisposed her to stroke was not known. And for that matter, if the GP had even attended to her earlier, it's not something that the doctor or the general practitioner will have been prompted to suspect, since there was no previous history of such symptoms. Yeah, so we noted all this last time that we met. And I think we were going to discuss this aspect of causation. That is where we have multiple causes of the plaintiff injuries, where the, like the other areas that we've been discussing, the other decided cases, you notice that maybe the plaintiff's injuries were definitely as a result of the defendant's negligence. That could be established. But what about where multiple causes are involved? In other words, you have more than one particular cause of the injury that the plaintiff is complaining about, as it were. Now, in a very good illustration, which we find from the case of Wilshire against SS, and those who have been referred to work on that, you need to read like the full judgment. And of course, not only those people, all of you, you have to read the full judgment. It's very interesting. You have met it already in your law of thought, but in medical law, we would like to read it with a particular focus. So you have to read it again. In Wilshire against the SS Area Health Authority, we have a case where a premature baby suffered from a number of disabling conditions, and the plaintiff claimed the blindness from which the baby suffered was caused by an excess of oxygen. Now, during the trial, it was also acknowledged that there are a number of different possible causes, meaning that it is not only the excess oxygen that might have caused the blindness to the baby. Now, in the course of the trial, it was not conclusive as whether the excess of oxygen actually caused the blindness or materially contributed to the blindness of the baby. In the lower court, that is the trial court, they came to conclusion that the defendant had caused the injury, despite the fact that it was impossible to pinpoint the precise contribution the negligence made to the baby's condition. But eventually, when the matter got to the House of Laws, the appeal by the defendant, that is the Area Health Authority, was allowed. And the courts rather followed the decision in McGee against National Coal Board. And at this stage, I would like to benefit from your knowledge from law of tort. Who will tell us about the case of McG against National Coal Board? Yes. Anybody raise up your hand and then I'll release you to talk? Or just pick anybody at a random. Okay, let me call Erabi. Who is Erabi? Era? Who is Erabi? Erabi. Yes, you can unmute yourself and tell us. Erabi is not minding me there. Okay. Let me go to Anne. Anne. Anne Abasiafa. Tell us MACD and National Coal Board. Anne? Oh, why? I'm not talking. Is Anne there?
Hello, sir.
Yes, Anne, I'm listening. Yes, go ahead. Oh, why? She's not talking. Okay, let me call another person. Martin Wang. President. Incoming president.
Yes, sir.
Yes.
Please, sir, can you hear me?
Yes, I can hear you.
Okay, so in that case, the defendants had employed the plaintiff, that's the claimant, McGee, to work on some break claims, but then they failed to provide a washing area so that the employees could remove the dust from the claims at the end of the day. And because of that, he contracted dermatitis. So the question was whether the claim, the act by the defendants constituted a breach of their duty of care owed to the plaintiff in that regard. So the court was saying that the failure by the defendant to provide a washing area so that the dust could be washed away increased the likelihood or materially increase the likelihood of the plaintiff contracting or developing dermatitis as a result of their failure to comply with the statutory duty to provide a washing area in that respect. That's what I remember about it.
All right. Okay. Yeah, so you see that.
Hello.
Yes, Martin. Martin, were you talking about?
Yes, sir.
Yeah, go ahead. Have you concluded?
Yes, I'm done.
Right.
Yes, sir.
Right. Thank you, Martin. Martin Wang.
Oh,
So,
Wana and Wan.
yeah, Mr. Martin Wanang. Yes, sorry. Yes, good. Thank you. Yeah. So you see how the court was emphasizing what we call the material contribution or substantial contribution to the injury. So in the Wilshire case, the burden was on the plaintiff to show that on a balance of probability or preponderance of probability, as we call it in our jurisdiction, that the excess oxygen caused or materially contributed to the risk of injury. And that's the plaintiff was unable to prove this, the claim failed. Yeah. So what we have to appreciate is that, yes, generally, it is a Bradford test which is applied. But we can also notice that on a number of occasions, the courts have applied what we may term a common sense approach to the issue of causation. In other words, it's not all type of medical negligence cases in which you'll be able to get a straightforward application of the Bradford test so as to dispose of the problem of causation. And sometimes the Bradford test, as we have seen, is not very helpful, especially where you have like the multiple causes and the court may have to take a broader look at the circumstances and make a determination as whether the injury which is being complained of can actually be attributed to the conduct or omission of the defendant on occasion. So look at cases like the Fairchild against Glenhaven Funeral Services, and also the case of Bailey against Ministry of Defense. And in the Bailey against the Ministry of Defense, for example, you notice that the English Court of Appeal held that in cases of cumulative causes of injury, where there is no certainty of medical evidence of a probability that, but for the defendant's negligence, the injury will not have occurred, it is only necessary for the plaintiff to be able to prove that the negligent act of the defendant was more than a negligible contribution to the plaintiff's injuries. In other words, even where we do not have a clear cut, evidence to say that the defendant's conduct or the defendant's omission significantly or materially contributed to the plaintiff's injuries. Bailey against Ministry of Defense suggests that in a situation like that, it will be helpful if the plaintiff could demonstrate that the contribution of the defendant was not negligible, not insubstantial or inconsequential. In other words, then you have like the burden to show that, yes, even if I cannot show that it was like the defendant's conduct or omission which materially caused the injury, it can also be demonstrated that what the defendant did was not something minor, something irrelevant, or something tangential. But so if you could actually show that it was not negligible, then the courts may probably be persuaded and fix the defendant with liability. So all these things we are saying reinforces the point which have been made that sometimes the court in dealing with the problem of causation may use what we call like the common sense approach. And if you look at even the Belay, how just explain it is really example of common sense being applied. And if we look at, let's say, the case of a Chapel against Hearts, one High Court judge, Kirby, was quite emphatic that the consideration of the question of causation is essentially a question of application of common sense. And he made this particular dictum, and I quote, if, but for the negligent act or omission, the actual damage suffered by the plaintiff would not have occurred, then one can conclude in the plaintiff's favor. Yeah, so if you look at it, yes, although some reference has been made to the Bradford test, but if you look at how the judge is putting it, is practically saying that in dealing with the question of causation, more or less using everyday wisdom, like the common sense. And that is why we say that if it had not been for the act or omission of the defendant, the whatever damage or loss which the plaintiff is complaining of would not have occurred, then the conclusion is to be that the defendant is to be blamed or is to be held liable for the injury or the damage the plaintiff is complaining of. Yeah, so that is what we have to pay attention to. But it is also possible that if we can have a situation that if the damage will have occurred in any event, that negligent act may not be the legal cause. Yeah, so you see that we are moving more or less from the factual, if you like, the causation to the legal causation. Because you can have a situation where even if the damage will have occurred in any event, as we even saw in some of the other cases, then you can say that the negligent act, that is a breach of the duty of care, is to be blamed as having caused whatever injury the person is complaining of in law. And there are interesting ways in which the issue of causation has been addressed in some other jurisdiction. But of course, in our own jurisdiction, if you look at the case of the Nkrumah case, as well as the Jan case, and all that, you notice that follow the usual Bradford test, as we have seen. And now, if you look at the Kenyan case of Snell against Farrell, it demonstrates a more creative interpretation of the issue of causation. And in Snell against Farrell, the courts apply what do we call like the common sense approach in absence of scientific precision to contrary to include in the claimant's favor. In other words, the court was saying that insofar as there is no scientific precision, there is no evidence to scientifically say that the injury was as a result of what the defendant did or what the defendant failed to do, then we are using the common sense approach to try and find out if we can blame the injury on the defendant. Yeah, so that is the common sense approach. So I would like you to look at all the cases that we have mentioned in the news, the Kenning Kashava against Sandwell and West Birmingham Hospital NHS Trust, as well as the case of Ingram and Williams. Now, what about where the alleged negligence concerns a failure to act? Where the alleged negligence is about the fact that because it's not really about, if you like, commission, more or less is about omission. And on this, I remember very well that last semester, I asked you to read the case of Montgomery against Lancashire Health Board, that Scottish authority, which made its way to the Supreme Court, which appear to have actually endorsed the doctrine of informed consent under English medical law. Yeah, but before we say more about that, where the alleged negligence, as I said, is not really about what the healthcare professional did and probably did not do well, but it's about the failure of the healthcare professional to act or to do certain things. How do the courts go about such a scenario? Maybe a useful point to look to is Bolaito against City and Hackney Health Authority, which concern whether something should be done, which has not been done. In other words, of course, you notice that in that case was really about taking certain procedures or not taking certain procedures. If you are giving a patient with certain conditions based upon how certain cases are done, will you have done this or you not have done that? Yeah. So the House of Laws concluded in Bolaito that where the defendant negligence is an omission or failure to act, causation can be established if one, the claimant or plaintiff can prove what the doctor who have done, she attended the patient. And two, if the doctor had not intubated the child when she attended, will this have been negligent? And I hope you remember the facts of Bolaito from last semester. So let me get one of you to quickly recount the facts for us. Those I call who Nana is Nana in Nana Jumo. Okay, so we have Nana Jumo here. Nana Jumo, can you recount the facts of Bolaito for us? Nana Jumo. Are you there? Okay, Nana Jumoto behaving like a rat and who will not talk. Okay, so let's take yes, Frank Edu Dati. Frank Edu Dati.
Doc, can you hear me?
Yes, please. Bolaito against City and National Health Authority.
Okay. What I remember is that from sermon to deal with the matter never received. Subsequently, the child to that.
Oh, and then
So the mother sued.
Frank.
So the mother sued for negligence.
No,
That the child.
I think Frank's line is not very clear. So let's take another person. Let's hope that the sound quality will be better. So Deborah Dona. Deborah. Deborah, yes. Oh, why? Deborah. Deborah will not talk. All right. Okay, so Matt. Okay, then let me go back to any volunteer. Who volunteer? Our friend was doing well, but like the sound quality is not good, so we can't hear him well. Okay. Okay, Gabriel Anane Enin. Gabriel Anane Enin.
Hello, sir.
Yes.
So in that case, as Frank was saying, a child was brought to the hospital who was suffering from breathing abnormalities. So when the child came to the hospital, the doctor was summoned to deal with the matter. Never received the summons due to a low battery on her bleep. At that time, they were using a pager. So the child died as a result. The child's mother sued for negligence, and her argument was that the child should have been seen and intubated. Um, the court held that the doctor held no liability because, per the House of Lords, it is not possible for a defendant, in that situation, to argue that a breach did not cause the harm, because for the breach, some other breach would have been a commission as opposed to an omission, and as such, it was necessary to assess whether the doctor would have been in breach if they had attended and not intubated the child. So the House of Lords clarified the Bullock test in this situation as a proviso that the parties accepted, a more proper but a reasonable body of profession.
Okay. All right. Yeah. All right. Thank you very much, Nana. Yeah. So in Bolaito 2, as we have just heard from him, the causative link was missing. The causative link was missing because it was proved during the trial that even if the doctor had attended the patient, she would not have intubated him. Yeah, so here, the question is, okay, a particular procedure was not done. If that procedure had been done, probably this outcome would not have occurred. But what about where you have doctors who say that they will not have intubated? So therefore, even if it's intubation, which you expected to have actually prevented the outcome which you have on hand, that will still have occurred. Yeah, so please, you also look at a more relatively recent case of the CJL against the West Midland Staffordshire Health Authority. And over there, the plaintiff was in labor and the midwives were concerned about the fetus and called the obstetrician. The obstetrician failed to arrive. I told you a certain story when we started medical negligence, and it's very similar to this. Failed to arrive within a reasonable time, which certainly breached his duty of care to the patient. And during the trial, evidence showed had the baby been delivered earlier, he would have had either no brain damage, or if there will even be brain damage, it will be a very minor one. So the defendants were held liable for the obstetrician's failure to deliver the baby quickly enough after it was discovered that a baby's condition was deteriorating. Because here, at least, we are getting the sense that if there had not been a delay, there wouldn't have been any brain damage, or even if there would be brain damage at all, it would have been very minor. Now, I told you about this case in one of our hospitals in Ashanti region, where somebody was going to deliver, and initially the person did not show any signs as whether she would need cesarean session. But during the labor, the labor pains and all that, when she was calling for CS, and the doctor, who was just a houseman at the time, and the supervising medical officer some meters away, but could be reached on call, actually failed to do the CS until last minute, when the oxygen level the baby or the fetus had gone down, and eventually the fetus died when the mother was cut, and then the fetus was removed from the mother. So as whether you say that if the attending healthcare professional had conducted the CS earlier enough, the fetus would not have died. Now, if scientifically it can be shown that yes, if the fetus would not have died, if there had been like the timely CS, then you could probably blame the death of the fetus on the negligence or the omission of the attending physician, because there was a failure to act, a failure to carry out CS at the time, which could have, for example, saved the situation. Similarly, in Goldsmith against Mid Staffordshire, a 2007 decision, we see how a doctor failed to refer a patient to specialists about an injury to her finger. And the Court of Appeal, the English Court of Appeal, held that where there is a failure to refer a patient to a specialist, and it is not known who that specialist will be, it is necessary to apply a fictitious scenario and consider what treatment will be more likely to happen. So the defendant was liable, as it was more than likely that if she had been referred, her condition would have been operated upon, which would have avoided amputation to suffer. Now, if you come to Ghana, for example, we don't take medical malpractice very seriously. Otherwise, there are a lot of health facilities which are more or less supposed to be like even like a primary care, or like just a general practitioner, a GP. And for that matter, some cases which are complicated and require specialist attention should not be handled there. They will not make referral. They will just be attending to the patient, and the patient will die, or the patient will suffer some serious complication, which will ultimately affect that patient's quality of life. And people, because of either ignorance or whatever, people don't take these matters up, because there are certain cases which should not be handled in the small clinics around. They have to make referral to, let's say, the regional hospital or to the teaching hospital, as it were. So, I mean, that is the lesson to be drawn from Goldsmith against Mead, Staffordshire. Now, what about loss of chance? Loss of chance cases, that is where it is alleged that because of the breach of duty of care by the defendant, the plaintiff was deprived a chance of full recovery. In other words, the plaintiff is saying that if the defendant had not done what he did, I would have recovered fully, or I would have survived, or I would have done that. Of course, you've met loss of chance also in the general law of tort, as well as a discussion of the Civil Liability Act of 1963 as well. Yeah, so the law is not very clear here. Maybe let's look at the case of a Hudson against the East Berkshire Health Authority, a 1987 decision, where a plaintiff, a 13-year-old boy, fell from a tree and injured his hip. Maybe this case has reminded me of the unfortunate situation which happened to my security during the COVID era, when there was this talk in town that if you inhale the neem tree, you know the neem tree, you put it on the fire and then you cover yourself and inhale the vapor. It was going to fortify your immune system and all the coronavirus will run away from you. So my security, I don't know whether he takes a little bit of alcohol, or I don't know, I don't have the evidence, but I suspect, climbed the tree, and unfortunately, he fell. And as I speak to you now, he'll be undergoing the treatment. So in Houston against East Berkshire Health Authority, we had a 13-year-old boy who also fell from a tree and had his hip injured. And the hospital was said to have breached its duty of care because it failed to treat him either promptly or correctly, which left him permanently disabled. And medical evidence showed that it was 75% likely that the boy would have suffered the same disabilities, even with the proper treatment. Now, in the trial court, it was held that a delay to treat him meant that the risk of disability occurring was vastly increased. And for that matter, the defendant was held liable for the condition of the plaintiff or the claimant. Of course, the defendant, that is the health authority, appealed the decision successfully to the House of Laws. And the House of Laws came to the conclusion that unless the plaintiff could prove unbalance of probabilities, or in our part of the way we say the preponderance of probabilities, that the delayed treatment was at least a material contributory cause of his condition. Causation will fail. So we see how the court is even trying to come back to this materiality of contribution, or the material or substantial contribution doctrine. And the court was of the view that it had to be satisfied that it was more likely than not that the injuries of the boy would not have occurred had the defendant, that is the hospital, not been negligent. But it can practically be difficult to work out the mathematics, that is the percentage point, in terms of what might have happened had the defendant not been negligent. It's not all the time that you can easily work out that, okay, if the defendant had not done this, there is 60% chance, there is 50% chance, there is 90% chance that this condition would not have escalated, or this condition would not have worsened, or I will have recovered, or I will have done that. Yeah, so it's not all the time that you can reduce some of these loss of chance to mathematical precision. Now, if the courts decide that the claimant or plaintiff will have had a 51% chance of recovery in full, but for the negligence of the defendant, then the plaintiff or claimant can recover the damages. But if the plaintiff or claimant have had a 49% chance of recovery, then the plaintiff will fail in their claim. So some kind of, if you like, there's a rough arithmetic speculation that, okay, if scientifically we can say that had it not been what the defendant did, the plaintiff had 51% chance of recovery, then clearly we can say that the defendant is to be held liable. On the other hand, if the plaintiff had only 49 chance of recovery, had it not been maybe the negligent act or omission by the defendant, then the plaintiff or the defendant will not be held liable, or the plaintiff will not win against the defendant, as it were. Maybe you also have to look at the case of Atchison against Ipsum and St. Helier NHS Trust, a 2002 decision. And the court had to decide whether the disease would have stopped drinking if he had been told he had end-stage liver failure. And therefore, had the failure to advise him to stop drinking caused his death. In other words, if the disease had been warned that he had the last stage or the end stage liver failure, would that have induced behavioral change to let him stop drinking? It was found that the negligence was at least a material contribution of his death. And for that matter, his death could be blamed on the failure of the health professional or the hospital to have warned him that he had end-stage liver failure, as it were. Similarly, in Gregg against Scott, and some of you have been asked to work on these cases. In Gregg against Scott, the doctor negligently failed to diagnose that the plaintiff or the patient was suffering from cancer. As a result, his chance of long-term survival was reduced from 42% to 25%. However, even if he had been properly diagnosed, that if he had been diagnosed earlier and all that, it was concluded that it was more likely than not that his condition would have been cured. And for that matter, the negligence had not caused his loss of chance. Yeah, of course, when it comes to, let's say, cancer cases, the loss of chance can be more complicated, especially where maybe early diagnosis of cancer could have prompted a very early treatment and management so that it does not escalate, it doesn't become more serious and all that. And where the diagnosis is later in time, making treatment very difficult. I think that is where decisions in the Gregg against Scott and all that become very interesting, because eventually when Gregg and Scott made its way to the UK House of Lords, the House of Lords held that on balance of probabilities, the delay in treating the patient for cancer did not affect his chances of recovery. And the court relied on the case of Fairchild, which we have seen earlier on, and where the court appeared to be more receptive to the plaintiff's position. So the decision in Gregg against Scott is a confirmation that is not likely that the court is going to have, if you like, one consistent approach in medical cases when it comes to loss of chance. And in all situations, the plaintiff will have to prove the case on balance of probabilities. In other words, the court is not simply going to say that because of this precedent, okay, if that is it, then automatically we can say that the defendant is liable for your loss of chance. No, you still have to go through the usual rigor of trying to prove the case on balance of probabilities. And that is why Lord Phillips in Gregg and Scott was at pains to point out that, quote, it seems to me that there is a danger if specialist tests of causation are developed piecemeal to deal with perceived injustice in particular factual situation, that the coherence of our common law will be destroyed. Okay, so what is happening is that we have Lord Phillips, who is actually trying to say that let's use the usual common law approach, the precedent. Once there's this precedent is there, then why do you have to go through the hassle of trying to prove a particular point? And that was why Lord Nichols dissented. And in his powerful dissenting opinion, he had this to say, quote, the law should be extremely slow to disregard medical reality. In these cases, a doctor's duty to act in the best interest of the patient involves maximizing the patient recovery prospects, and doing so, whether the patient prospects are good or not so good. In the event of a breach of this duty, the law must fashion a matching, meaningful remedy. It cannot be right to adopt a procedure having the effect that in law, a patient prospect of recovery are treated as non-existent if they exist, but fall short of 50%. if the law were to proceed in this way, it would deserve to be likened to the proverbial ass, unquote. In other words, his lordship did not see any sense in trying to say that if the recovery chance, for example, is below 50%, then you write the case of the plaintiff or the patient off and say that since the evidence shows that you had less than 50% chance of recovery, then we cannot blame the defendant for his failure to have done a particular thing, and so forth. Now, Lord Nicholas was saying that that is not really a very sensible way to go about it. Now, I would like you, especially the group, which will be dealing with that question, you have to relay the full judgment and actually come to discuss with us in the seminar what your thoughts and reaction are to what these laws are disagreeing about with respect to loss of chance. And of course, a very important case which we need to pay attention to is the case of a Chester against Afsha. And I must say that until the case of Montgomery against Lakinashe was decided in 2015, the case of Chester against Afsha, 2004, was actually celebrated as bringing some kind of sanity in the post Bulaito era. Of course, Bulaito had been seen as also trying to bring some kind of discipline to Bolam tests, and Chester and Afsha was even seen as having taken the application of Bolam to another higher level, until, of course, in 2015, as I said, we've had like, with respect to disclosure of information, we have had a more recent decision in the Montgomery case, which I have been talking about. Now, so in the Chester against Afsha, the court made the point that the patient has right to be fully informed of the risks of the operation. He has a right to be fully informed of the risks of the operation. If you remember the case of the, what do you call it, the Sidaway. Remember Sidaway came and there was this debate as to what level of risk must the patient be told before the patient can be said to have given his or her full consent to a particular procedure, so on and so forth. Now, Chester and Afsha came to say that the patient has the right to be fully informed of the risks of the operation. And by the way, let me find out, last semester to ask you to read the case of Chester against the Afsha. So what happened in the case of Chester against Afsha? Abigail Kusi, can you tell us what happened in the Chester against Afsha? Abigail Kusi? Abigail. Yes. Okay, Sam wants to help. Abigail Kusi will not talk. Okay, Samuel, you can mute yourself, right? Yeah, Samuel, go ahead.
Okay, sir. Mrs. Chester suffered from back pain. Yes.
Yes, go ahead. Samuel, go ahead.
Please, can you hear me, Doc?
Yes, I can hear you now. Yes. I can hear you. Go ahead. Hello, Samuel. Oh, what is happening? Samuel, go ahead. I think there's a, let me do it for him. There's a bit of a, okay, I think his line has gone off. So since Samuel is off, who volunteer? Mr. Bedu, are you here? Simon Bedu. Simon. Simon is not here. Okay. Okay, then let me take Rukaya Ahmed. Rukaya. Oh, so you don't read the cases. This one, okay, let me come back to Afari Wallace. Afari Wallace. Afari Wallace. You can mute yourself. Okay, Anne. Anne.
Yeah. Hello, sir.
Yes.
Sir, please, I couldn't read the case.
Oh, wow. That's a mister. Afternoon. You haven't read Chester and Afsa. Okay. You, Era, who is Era? Era B, who is that? Era. Era B. Okay, Elsie.
Hello. Hello.
Go ahead.
Hello.
Yes, go ahead. We can hear you.
Hello.
Yeah, we can hear you.
Okay. And so in the case, Miss Chester had back pain, and surgery was
Oh,
as a solution, but the 1 to 2%, and it came after the surgery. She experienced that complication, even though it was a very slim chance. And the judge held that the doctor was duty to inform her of. She herself had said that had she seek the court held that the doctor had not discharged his duty to her and had not given her the opportunity to take an informed decision.
hello. Hello. Yeah, are you there? Yeah, okay. So I think we are having a challenge with the connectivity, but at least he's told us the substance of the. Okay, else is as your meter again. Okay. Let me actually unmute all of you, but make sure that make it. Yes.
Sir, please, did you miss part of what I said? Okay, so I was saying that because the doctor did not inform her of the court held to discharge that duty to her vibes to
Yeah. Okay. All right. I think we're having a challenge. It's all right. We need to. Thank
there was a connection between his failure and injuries she sustained.
All right, thank you, Elsie. Thank you. Yeah. So the Chester and Afsha is looking at the situation where a patient, for example, was not told certain information regarding risk associated with a certain procedure, and the person will say that, okay, if I had not been told about that procedure, I wouldn't have probably if I had been told those risks, I wouldn't have consented. Or if I had been told the risk, I would have consented. Yeah, so that is the situation about Chester and Afsha. But as I said, the more recent case of Montgomery says that regardless of anything, the patient is entitled to know everything, which will help him or her to make a decision as whether he or she will accept a particular proposed treatment. And that was why, if you look at the Chester, Lord Hope, for example, will say this, and we contrast that with what the position of the law has been now in the light of Montgomery. And Lord Hope in Chester will make the point that the function of a law is to enable rights to be vindicated and to provide remedies when duties have been breached. Unless this is done, the duty is a holy one, stripped of all practical force and devoid of all content. It will have lost its ability to protect the patient and thus to fulfill the only purpose which brought it into existence. On policy grounds, I therefore will hold that the test of causation is satisfied in this case. But of course, if you look at this particular case, the Chester against the Afsha, as we have said, the patient was not told about a particular risk connected to an operation to relieve back pain. And when the risk occurred during the trial, she could not categorically state that she would never had operation. In other words, if she had been told about the risk associated with the back nerve surgery, whether she will still have undergone the operation. During the trial, she couldn't state that right away. And she had to be able to prove that she never would have had operation had she known about the risks. But it was also evident, or she stated during the evidence, that she would have sought a second opinion and probably would have gone ahead with the operation, but on a different day. So what is happening is that the patient is saying that if the doctor who attended to me had told me about this risk, I could have gone to another expert to seek a second opinion before I'll make up my mind. And because I was not told, I couldn't have gone for second opinion, or probably I could have also avoided even undergoing the procedure. And the risk that I have suffered now would not have even have materialized. And in if you like a very, this is not, it's about what will have happened or what will have happened. It's not really the where somebody did or failed to do particular procedure, but this one's about information sharing. So what amount of information was the attending physician obligated to give to the patient before the patient would have decided one way or the other? Now, with respect to remoteness of damages, I would like to remind you that what you learned in general law of torts, the wagon among number one, and all those type of cases are very applicable to medical negligence. And for that matter, we will not waste a lot of time. So by the remoteness here, we are talking about the fact that yes, when we have established that a particular injury occurred as a result of the breach and all that, what heads of damages or what type of compensation should we be allowed to recover? And that is why the wagon more number one will tell us that the damage must be foreseeable, although the actual extent of the damage need not be. So that is to say that the type of damage should be foreseeable, but the full, if you like, the spectrum or the full extent need not to have been foreseeable for it to be recoverable. And that was why in R against the Croydon Health Authority, where plaintiff had undergone a chest X-ray, the plaintiff alleged that she would not have subsequently become pregnant if she had been warned of a particular abnormality that would be worsened by her pregnancy. And she argued, had she been aware of the risk, she would have terminated her pregnancy. And for that matter, she sued, claiming to recover costs arising from the birth of a child. And the court held that her claim could not be upheld because her claim was so remote. In other words, the claim for the expenses in having the child and raising the child is far remote from the failure by the health professional to have disclosed the risk of that abnormality. Yeah, so as I said, this is no different from what you know from a general law of torts. And of course, in terms of defenses, all the things that we know, res ipsa locuto, and the contributory negligence, illegality, and then the estopi causa. As we know from general law of tort, they are applicable mutatis mutandis, and especially voluntar non-fit injuria. They are all applicables. And because we have learned this in general law of tort, and because of time, I will not actually belabor the points. And of course, finally, the law on limitation of actions. So the limitation decree or the limitation act of 1975 is also applicable. It can be fit for claim, especially so where the claim has been delayed for a long time. So that is what you should mind. Yeah, so we will end the discussion of medical negligence here. And yes, I've seen somebody, yeah, Martin